Welcome to the second in a three-part series of expert talks focusing on patent portfolio strategy. My name is Ian Jones. I have a background in pharmaceutical research and I'm a chartered UK and European patent attorney at Gill Jennings Every in the chemistry and life sciences team. The patent lifecycle can be split into three parts. The first is preparation, which we looked in part one of this series. The preparation phase looks at preparing your company for its IP journey. It provides a set of fundamental processes that you should consider implementing to help capture innovation within your company to ensure that it achieves its commercial goals. In this part, we're going to look at the implementation phase. This includes processes and strategies used to generate registered patent rights. The final section, which we'll explore in part three, looks at monetization. At the end of the day, that's what it's all about. We're going to look at discussing the common ways to generate revenue from your IP to make it work for you. So now we have the necessary processes in place and the preparation work has been done. We have all the information needed to demonstrate the invention works, and now it's time to draft your first patent application. Ideally, a patent attorney should be involved at the innovation capture stage, particularly if research is ongoing within your company, as they're trained to spot patentable innovation. However, if this has not been the case, then now's the time to onboard them. The basic elements in a patent application are the claims, the description, and the drawings. The claims define the scope of protection offered by the patent and are generally considered one of the most important parts. The first claim would typically be the broadest and will set out the essential elements that are required to make the invention work. What follows that are a series of numbered paragraphs that get more specific in detail and should focus on your commercial products. Essentially, if your broad claim lacks patentability for inventive step or novelty purposes, you can fall back to your narrower, more specific claims. You typically start by drafting the claims of a patent application. There usually be a bit of to and fro between your patent attorney and you before everyone's happy with the claims and you can move on to the description. The description is how to put the invention into effect. It's very important because it must be clear, it must clearly inform the reader in sufficient detail how to carry out the invention. Examples are a great way of showing how the invention works and have become almost mandatory in the chemical and life science fields as a way of proving that the advantage of your innovation is actually achieved. It is also important to note that during examination of the patent application, we may need to amend the scope of the claims based upon the information in the description. Some patent offices, in particular the European Patent Office, have very strict rules on this and allow only certain combinations of features from the description to be combined. So drafting a description is not just a matter of writing about the invention. A patent attorney has to use their knowledge and experience of both the technical field and the law to ensure that options are kept open for your company further down the line. The drawings are usually a visual image or a photo of the invention, or perhaps graphs of data which can be used to support the invention. They're usually dealt with together with a description. Now, a common question is, how long does it take to draft a patent application? I've drafted applications in a couple of days, and I know others who have drafted and filed on the same day. This typically happens when people become aware of imminent public disclosure, or they need to register the rights before they talk to a potential partner or investor. But those are special cases, and the drafting process should ideally take 2 or 3 weeks. This gives everyone involved the time to consider the points more thoroughly. Considering you can't amend the application once filed and the potential implications of not doing it correctly, it's essential to make sure that this part is done right. So now you're well on the way to having your patent application drafted. The next question is, where are you going to file it? At this point, you need to consider your filing strategy. This can be influenced by many things, but the fundamental considerations are, what country will you first file in? We've heard already that where the invention was made may have an impact on where it needs to be filed. Whether you want the application searched, this may be the first time we've had a third party search your invention. And what are the other countries in which you want to pursue patent protection? Again, this is heavily influenced by your company's business plan and commercial goals. What I want to share with you today is a patent attorney's go-to filing strategy. This essentially acts as a starting point for discussions and outlines what you're able to do within the patent system. Now let's kick this strategy off with a few assumptions. I'm going to assume that your company is based in the UK. This is your first application in this technical field, and you've only conducted your own searches. In this case, I'd recommend filing the first patent application at the UK Patent Office. There are many reasons to do this, but a key advantage for your company is costs. It's very cheap to file a UK patent application at the Patent Office. In fact, the UK Patent Office doesn't charge a fee just for the filing, and also the search fees are relatively cheap. So we file the application at the UK Patent Office on the 1st of January 2020. This just makes the timelines a little bit clearer. And let's say that it discloses your current innovation, which we'll call Invention A. Patents typically have a lifetime of 20 years, and so the UK patent will expire, once granted, at the start of 2040. Now, the filing date of the 1st of January 2020 is very important, as it plants your flag in the sand. Once your application is examined by a patent office, only publications available to the public the day before the filing date can be used to assess the patentability of Invention A. So that's anything published before the start of 2020. This is why it's so important to file your patent application before publicly disclosing your invention. But patents are territorial, so having a patent only in the UK may not support your company's business plan. You're likely to need patent protection in a number of other countries that represent your key commercial markets. And as luck would have it, there's a way of extending that UK patent application into other countries. Patent offices around the world have agreed that you can have up to 12 months from the first application to file the same application in other countries, whilst assessing the patentability of those later applications, the ones in green, based upon the prior art before the filing date of the UK patent application. This is referred to as claiming priority from the UK patent application. So, if the US, China, and Japan were key commercial territories for you, we have 1 year, so until the 1st of January 2021, to file the same application in those countries and claim priority from the UK application to retain the priority date of the 1st of January 2020. Those US, Japanese, and Chinese applications are separate applications, and so their patent term will expire at the start of 2041, so 12 months later than the UK application. You can also file the same application in the UK again within that 12-month period, claiming priority from the original UK application. This means you will have protection in the UK for a further year, so again until 2041. This strategy is referred to as direct filing. And it's fine if you know you want protection in a limited number of countries and that you have the finances to support it. Filing at multiple national patent offices can be expensive, as you need legal representation in each country. There are also national fees that need to be paid, and some countries will also require translation of the patent application into a local language. But there is another way that gives you a little bit more time before you need to make those decisions, and a bit more time to test the local markets. And that's by filing an international application, which is also known as a PCT application. Similar to direct filings, a PCT application can be filed up to 12 months after the original UK application and retain the priority date. A PCT application extends the time you have to choose the countries in if you want to proceed by up to 30 months. That's 2.5 years from the original UK filing date. That puts us up around July 2022, and 1.5 years later than if you use the direct filing strategy. At that point, you'll be faced with the same cost-benefit decisions that you would have had to face at the direct filing route. But hopefully by then you're in a better position to make those decisions. After converting the PCT application to a national patent application, the National Patent Office will consider the application to be an exact replica of the PCT application, including its filing date. So despite having extra time to make decisions on which countries to proceed in, you don't get an extra 1.5 years of patent term. It's important to note that there's no such thing as an international patent. Once that 30-month date has passed, the PCT application has served its purpose and will lapse. A lot of SMEs will use that 30-month period to seek investment in their company. a portion of which can be put towards patent costs. Now, a lot can happen in a year. So by the time you want to file a PCT application, your company may have developed the invention. As we are effectively filing a new application, although it is claiming priority from the UK patent application, we can add new information to it. So let's say we add invention B, which is a slight improvement on invention A. Now, invention B was not in the original UK application, and so is not entitled to that priority date. Instead, invention B will be assessed based upon the public disclosure up until the day before the PCT application is filed. For this reason, we recommend that you treat your invention as confidential until 12 months after your initial filing. In fact, we usually recommend keeping it secret until after the PCT application is published, which occurs 18 months from the UK application being filed, so around July 2021. This is because you can withdraw an application before it's published to prevent it from being published, which you may want to do for commercial reasons. In part one, we looked at having the patent application searched by a patent office, and the fact that those results will be ready within about 6 to 9 months after filing. Now you can see why that 6 to 9 months might be relevant. You can modify the PCT application before it's filed based upon the UK search results. But doing so may mean you lose your right to priority, so this will need to be assessed by your patent attorney. So what you see here is a basic filing strategy, which can be modified to suit your company's business plan. And I hope you're starting to get a feel for the timescales involved. If we filed the UK application on the 1st of January 2020, we are already halfway through 2022 before the patent application is even in front of an examiner in a commercially relevant country. There are ways to accelerate this process, but again, this will come down to tailoring the filing strategy to your commercial needs. Typically, it takes between 2 to 7 years to start seeing patents granted once national patents are filed. Although this is very specific, so we could potentially start to see patents being granted from 2025 onward. Now in part one, you may recall my chess analogy. This filing strategy relates to one of those chess pieces. However, as your company continues to innovate, it's likely you're going to need to file new patent applications related to any of your advancements. So let's look at a basic patenting strategy and how to develop and grow your IP portfolio. We have already seen that information can be added to the application at the PCT stage before it's filed. But what happens if the innovation occurs after the PCT is filed? Or perhaps you want to keep those developments in a separate application. You need to know how your own applications will impact the patentability of those you file later. In this scenario, we file a first application which discloses a broad concept of your invention. In the pharmaceutical sector, this could be a broad marker structure covering a certain area of chemical space that contains compounds with interesting biological properties. An innovation capture session conducted later could reveal a specific subset of those compounds, which perhaps includes a lead compound. If we file an application covering that specific subset of compounds before publication of the first application, so any time up until around 18 months from that first filing, then the first broad application will only be available for the assessment of novelty of the specific application, the second application, in some countries. Now, I mentioned in part one that the prior art needs to be publicly available before the filing date, but patent offices want to avoid two patents of the same invention. So they usually require a later filed application to be novel over any earlier application in that country, despite the content of those earlier applications not being publicly available. But we know the content of the original broad patent, we drafted it. And so we can take it into consideration when drafting the latest specific application to ensure that it's sufficiently different. Now, further developments can lead to incremental advancements that may be patentable in their own right. And when drafting further patent applications to cover those advancements, we will need to consider the content of your earlier filed cases in terms of novelty, or both novelty and inventive step, depending on what has been published at the point of filing. So as you can see, filing successive rounds of patent applications that focus on improvements over earlier filings forms the basic the basis of a patenting strategy. The advantages of this type of strategy include increasing the duration of market exclusivity, as later filed applications will expire later. It strengthens your IP portfolio, with third parties having to commit more resources to clearing their path to your market. And it also increases the options available to you to monetize your patent portfolio. So this covers the basic filing and patenting strategies. And now you're starting to amass IP rights. You need some way of tracking them, and that can be done using an IP database. But an IP database offers so much more than just tracking your patent assets, with many of the offerings being linked. You can use it to map your patents to products. It's not uncommon for a product under development to end up outside the scope of a patent, the patents that are supposed to protect it. The database can be used to estimate future costs for budgeting purposes, and it's obviously a go-to resource when conducting an IP audit. It can store details on competitor patents that you found during your innovation capture sessions. And from a commercial point of view, it can be used to track licenses and agreements. There's nothing worse than wanting to streamline your patent portfolio and not knowing if you have obligations to third parties to maintain cases. Believe me, this happens. However you want to use your IP database, you want to be sure that it captures the information necessary for you to be able to make informed decisions on the future of your company. So this brings us to the end of the second session. We've explored the preparation, we've explored the implementation part of the patent lifecycle and introduced a number of processes that you can use to start generating IP rights. Part 3 will focus on monetization of your IP.